to Financial Insider Weekly. I am your host, Michael Gray, CPA. My guest today is Naomi Comfort. Naomi is an attorney with Hawks & Comfort, LLP. She has taught continuing education courses on fiduciary income taxation and has made team presentations with Michael Gray, CPA, about handling retirement accounts after a death. And we talked to lawyers, CPAs, and the public. And that has led me to ask her to join me to discuss the topic today. I will mention also that Naomi's practice actually focuses more in the elder law area now, and so she deals with special needs trusts and other estate planning issues and Medicare planning and all that good stuff. So I want to give her a good plug there. So Naomi, thank you so much for joining me today.
You're welcome, Mike. Thanks for having us.
Okay. So today we're going to be talking about handling retirement accounts after a death. And before I get started, I want to caution our viewers that we're just covering some highlights of an enormous area of tax law and rules related to inheritance. And so please just view this as a bare starting point to learn about some issues, and we want you to see an attorney and continue this conversation, and possibly also an estate planning CPA and other estate planning team members, financial planners, and so forth. So we're talking about retirement accounts like qualified plans, like profit sharing plans, 401k plans, IRAs, and Roth accounts. And it's a big field. And I'll mention, anyway, there is a big book that we refer to related to this, and it's income and death planning or something like that for retirement plans.
And there's also the big IRA book.
In a big IRA book, okay. So there are references that people will find helpful, and that the website that I'm thinking of is called ataxplan.com. Where you can get some information about that if you'd like to get a copy of that book. Okay. Well, Naomi, let's get started with our questions. Aren't retirement accounts just handled as part of the process of probate and trust administration?
Well, no, actually they're not. And it's very, very important to specifically deal with these assets, both your own during your lifetime and also when somebody passes away, they have to be appropriately handled. So from a planning perspective, during your lifetime, those assets are not held in your living trust if you have a living trust. Because under tax laws, they have to be in your individual name during your lifetime. And then you, on the company's form, will designate a beneficiary who is going to receive the balance of what's in that account after you've passed away. So it is not part of your trust administration unless you've named the trust as the beneficiary of your IRA. It is not part of a probate estate unless you've failed to name beneficiaries, or the beneficiaries you've named have predeceased you and the plan doesn't have any backup alternative beneficiaries. So with respect to who it goes to after you pass away, it's very important that even when you're doing your own estate planning, that you address these assets separately, in addition to making sure that you fund your living trust, or know who's getting what under the terms of your will. This is a contract, and it goes by beneficiary designation at your death to the person that you've named under a beneficiary designation form. The other element of this, so whether you have a small estate or a large estate, a big IRA or a tiny IRA, you still should consider who's going to receive that and make sure that the beneficiary designation is complete and up to date. So from a planning perspective, that is very important. From a tax perspective, that is part of your gross estate that could be subject to estate tax when you pass away. So from that portion of the administration, when we're looking at these, even though the beneficiary might be outside of what the estate or trust attorney is handling, it's going to be valued for purposes of determining whether or not there was a taxable estate. So say my client had a $6 million estate and died last year in 2010 when there was a $5 million exemption. And let's say $4 million of that was an IRA account that went to child number one, and the rest was her home that went to child number two under the terms of her living trust. Well, the IRA beneficiary, child number one, would just go down to Schwab or wherever the account is, fill out a form requesting, indicating that they're the beneficiary and how they want to take that. That asset goes directly to that beneficiary, and the trust, which has the house and says the house goes to child number two, that the trustee of that trust is going to do an estate tax return that shows that the decedent owned the house and the $4 million IRA account, and there's going to be a tax liability that is shared 60% by, I'm not going to get the numbers right because I don't do numbers. I'm a lawyer.
That's all right.
But the $400,000 IRA is going to has to pay their proportional share of the estate taxes. So from some perspectives, from a tax perspective, the attorney representing the trustee may have some involvement in what's going on, but it actually passes outside of the trust and outside of the probate estate unless those are designated as the beneficiary or there's been a failure of the beneficiary to take the actual account.
Right. And I guess we can put in, I mean, you just sort of raised, a potential problem or issue, and that is people have to communicate with each other and be willing to share information in order for those things to happen, to have that estate tax done, estate tax return. And if they don't, then there's a real problem, and unfortunately, you may end up having to get IRS involved in order to get the information.
Exactly. So what could happen is sister number one, who took the $4 million IRA, refuses to pay her share of the estate taxes,
or even tell them what the balance of the account is, or whatever,
exactly,
or the description.
And so it can become very difficult if, in the planning that is done during the lifetime, that the decedent and her attorney take into consideration the estate tax issues that are going to arise at death, and how are those taxes going to be paid when the only liquid asset is outside of the trust and is not going to be marshaled by the trustee and won't be a source for having the liquidity to pay that huge tax bill that's due 50 cents on the dollar basically on anything over the exemption amount. So it is a critical planning issue, and we see all the problems after death when it hasn't been thoughtfully addressed by an estate planning attorney or by the client.
Right, okay. Well, I think we're going to move on because we can sort of dwell on this sort of stuff, like I said, forever, and meanwhile there's other information to get out. So why do retirement plans need to be considered soon after a participant dies?
Well, they need to be considered promptly because there are a bunch of time limits and time constraints that are immutable. They are in the code, they're in the statute, and if you miss a deadline, you're going to have serious tax consequences. So we need to figure out who the beneficiary is of that account, not just who the beneficiary that's named on the account, but who under the code qualifies as the designated beneficiary, because we've got to figure out how the calculation of required minimum distributions is going to work. We need to know if there's any savings efforts that we need to go through in order to maximize what's left in that retirement account for the beneficiary. So what we're looking at from the lawyer's perspective is somebody comes into us after death we're marshaling the assets, we're figuring out who gets what, we're looking at the terms of the trust, we're looking at the tax liabilities, and we are also looking at how are we going to maximize what's left here to distribute to the beneficiaries, which means how are we going to mitigate and minimize the tax liabilities. So we want to look at those retirement accounts, which are going to continue to be subject to income tax as the beneficiaries withdraw the funds from those accounts, and we want to continue to defer recognition of income as long as possible. The rules for withdrawal on an inherited IRA are different than for your own IRA or retirement account, because for your own account, of course, you are not required to take distributions until 70 and a half. On an inherited account, if the beneficiary is 4 years old, the beneficiary still has to start taking required minimum distributions. Now, granted, the beneficiary has a very long life expectancy, and we can probably have some very small distributions that are going to be coming out. But if we don't get those distributions set up and figure out who the beneficiary is, then we are going to maybe miss a required minimum distribution, and the penalty for missing a required minimum distribution is equal to 50% of the distribution that should have been taken. So, for example, I had a case that was in litigation for 4 years, and part of the litigation is who is entitled to this account. And there were no distributions made during the period of the litigation because that part of it was being handled outside, not in my office. So there were no distributions made during that time. And it turns out that the beneficiary was somebody in their 60s or 70s, and so the required distributions were significant, and for 4 years they weren't made. So if the required distribution was $100,000 each year, the penalty is going to be $50,000 each year. So it's really significant if you miss those deadlines, and really planning for how that is going to impact your own income taxes. It's part of the planning that the beneficiaries need to do for their part.
There's a couple of other things that I'll just throw out, and as you can gather, folks, this is huge, the area that we're talking. So Naomi can just rattle on, and fill in the whole half hour when I ask one of these questions. So
that's the problem with attorneys. You can ask us one question, we can talk forever.
But there are a couple of things I wanted to be sure to get in. One is that you may have a required distribution actually for the decedent.
Correct.
So if, for example, the decedent passes away in October, and they were over 70 and a half, they may have to have the distribution made for the year of death by December 31st. That's within 2 months after death, folks. Another thing is that when you're planning for some of these things, like Naomi was pointing out, that there are some pretty stringent deadlines that we have to make. And one of them is September 30th of the year following death. We can actually, in some cases, if we have many beneficiaries, we may want to divide an account. It has to be done. You have to know who the beneficiaries are and get the accounts divided by that September 30th following the date of death. So we've got very short time horizons here. And when the family is grieving and so forth, these things may not be addressed on.
Exactly, and there are so many issues